Good day, and welcome to the Advising the C-Suite and Boards of Directors on Cybersecurity webinar. Today's conference is being recorded. At this time, I would like to turn the conference over to Mr. Jim Harvey. Please go ahead, sir.
Thanks very much. Welcome, everyone, to today's webinar. We appreciate you attending, and I particularly appreciate the time of my co-presenters this afternoon. I'm going to go through the agenda real quickly and some administrative stuff, and then we will move to the appointed material. First of all, most of you in the audience are lawyers. We have arranged for CLE in states where we have offices automatically, and if you're in a state other than that, you will receive a certificate of attendance at the end of the phone call by email, and you can either use that to go get CLE credit on your own, or if you contact us, we'll help you with whatever state you'd like assistance in. We will also send a set of the slides after the presentation, so there's no need to do a screen grab or anything. We will provide them to you after the presentation. And your questions, if you have questions, we encourage you to ask questions. Given the format today, we weren't able to do audio questions, but if you use the chat functionality that should be visible on your website or on your computer screen there, we will monitor those questions during the presentation, and we'll either raise them if we can during the presentation, or we're going to reserve 15 to 20 minutes at the end for questions, and I'll simply read the chats that come in during the presentation and then ask the question to the presenters. We're going to cover the cybersecurity risk legal landscape and the role of the board and the C-suite in cybersecurity, and that really is going to cover pre-breach and during a breach, and even some conversation or comments about after a breach, and then cyber breach response, because if you've never lived through a breach, it is a unique crisis event, and unfortunately one that many companies are experiencing today. As I mentioned, next slide please. As I mentioned, my name is Jim Harvey. I am the co-chair of the Privacy and Security Group here at Alston Bird, and the co-chair along with Kim Peretti of our Security Incident Management and Response team. And I just ask our other presenters to introduce themselves and what they do every day in the breach world.
Good afternoon. My name is Jessica Corley. I chair our Securities Litigation Group here at Alston Bird. My practice is all manner of director and officer liability, and as well as counseling boards on corporate governance issues and cybersecurity risks and exposure.
I am Scott Ortwein. I'm the co-head of our corporate department here at Alston & Bird. My practice is primarily focused on representing public companies in all manner of things, M&A, corporate governance, and securities disclosure, as well as representing boards and committees of boards in extraordinary events.
Kim?
Yes. Okay. Thanks, Jim, and welcome everyone. Glad to be here today to talk to you about these issues. We thought we would kick it off just to set the sort of framework with a slide on the cyber threat landscape, which I think most of the audience will appreciate if they read the papers daily, that the landscape is rapidly unfolding. It's frequently evolving with sort of a continuous flow of unprecedented attacks. It seems like every other week. It used to be every couple of months or maybe every year. Now it seems to be every other week. There's an attack that you read about it that's labeled as unprecedented in nature and scope of impacted records, or the nature and the type of the attack that occurred. And all of that informs how we understand or attempt to understand the cyber risk exposure from these types of events. I like to use the example of in the cyber threat landscape of from exploitation of systems to disrupting systems to destroying systems to understand that landscape. And it was just a couple years ago in 2011 when our Deputy Undersecretary of Defense presented at the RSA Security Conference, which is the largest security conference in the United States, and he talked about exactly that, of the advanced threat actors moving up the ladder of escalation from exploiting our systems and stealing things. Maybe if you want to think about what we just recently read about in the Anthem attack, where it's being attributed to state actors stealing information. And he identified a second threat that was just emerging a couple years ago of disrupting systems. And since then, we saw that the state actors were doing that, a coordinated attack in the financial services sector to disrupt websites from operating. And then he also mentioned the third and most dangerous type of attack is a destructive attack, and that risk was only emerging at that point. And that was just a couple years ago, and here we are just seeing several years of destructive attacks, with ending last year an attack in the commercial sector, which again was sort of unprecedented. So all of this is very important as we try to identify and understand the cyber risk and take appropriate steps to mitigate these cyber risks to our organizations. Next slide, please. So breaches result in significant cyber risk. And what exactly does that mean? Well, first of all, it used to be that you had a much better ability to sort of control, if you want to think of it, control the breach itself, or decide if or when you needed to notify any other parties about that breach. And it's been increasingly difficult to maintain, the control over that exposure, and to keep a breach private, if indeed you do not have legal obligations to share the extent of it with any other parties. And one reason for that, or there's many reasons for that, but some of them are that there's security bloggers that are actively engaged in the security or the criminal underground, or monitoring the criminal underground and spotting attacks before other parties know about it. There's security researchers that are doing that. There's individuals that are posting, and criminals that are posting information on websites where the media is paying attention to them. We have the government indicting criminals, but also indicting state-sponsored actors, and we saw last year an unprecedented, again, example of that with the Department of Justice indicting the Chinese, some Chinese nationals for their attacks on systems. So, and we also have attacks happening on other companies where emails are exposed, and those emails might discuss a breach that occurred at your company where you were working with that company, or that company knew about it. So it's very difficult to keep breaches private anymore, and you have to anticipate that whether you have a legal obligation to disclose them or not, they may be disclosed. The second important point of understanding sort of why breaches result in significant cyber risk is because if they occur, it used to be more that there would be a smash and grab. A criminal could be attack one of your systems and steal something and be on their way, and it was over. And you could have a good control over understanding what happened and understanding the impact. Well, that's not the way it works anymore with criminal cyber attacks. They often get into systems, and it's their dual goal to get deep and prolonged access while they pilfer as many systems as they can, looking around. So it's often the case that hundreds of systems may be impacted. And then you have to investigate what the criminals did, and that's also where it's becoming more difficult because these investigations are highly technical and complex. The criminals' techniques that they use are very difficult to understand exactly what they did. They use anti-forensics so that they don't often leave forensic artifacts behind. And if you combine that with the fact that we are still at an average of many months before we attack advanced threats on our environment, and I think recently in a 60-minute interview, the FireEye CISO stated that it was an average of 200 days was the average time for detecting these types of breaches. The more time that passes, the less likely it is that evidence is available. And if evidence is not available, you're often in the position where you have to prove the negative. So you have criminals in hundreds of systems. They might have been interested in one system, but you have these other systems of customer data, confidential data, and you have to take the conservative approach that they were likely accessed by the criminals because you can't prove otherwise. And all of this taken together leads for, if you have these types of attacks, of course there's smaller attacks all the time, but many of the attacks now are bigger, and if they're bigger, they result in significant cyber risk.
Thanks very much, Kim. No, go ahead, Kim.
I was going to say the last thing I would mention is the type of risk that's involved. I think it's, folks understand that if you have one of these significant events, there's a couple different types of risk. Of course, there's, for many organizations where customer trust is very important, you have the reputational risk. So even if you can prove or have good evidence that it might have been a small incident that occurred, if it becomes public, you've got to work with your customers and consumers to restore your reputation. The regulatory risk, again, is changing dramatically, moving from just a few regulators that might be interested to more regulators, a sort of cascading effect of not only state AGs or the FTC, but also the SEC, which we'll talk about more today, increasingly interested, as well as health regulators and banking regulators. And then litigation, again, we are used to seeing if there's personal information that might have been at risk, a series of class action litigation you could expect from consumers or even from issuing banks in the area of payment card breaches. But also now we're seeing more in the area of shareholder derivative actions and otherwise, which I know Jessica and Scott are going to cover later. And before I move on, I have to mention the unique risk with respect to payment cards is what a very highly visible type of breach that we hear about a lot because it's a very active criminal underground targeting what's on the back of the magstripe data because it has a resale value on the underground. And those types of investigations have a unique risk because there's external third party, namely the banking partners, the card brands, that they have the ability to require the company to hire an investigator that reports to the brands, and thereby it's even more difficult to sort of maintain control over the investigation because you have external third parties directly involved in that process, and at the end of the day, with the ability to levy significant fines and recovery amounts. So Jim, I'll turn it back over to you.
Thanks very much, Kim. That's a good level set on kind of the parade of horribles that companies are experiencing on virtually a daily basis. I guess I'd ask Jessica what the board duties are and what does the board need to think about from a legal analytical perspective as we advise them.
Sure, thanks, Jim. So you directors are reading in the newspaper every day about these breaches, and they're asking, what are my duties? Do I need to be a cybersecurity expert? We have to start, I think, with the basic governing standards. And so for the board's duties, the same principles will apply as in other areas. There is no higher standard that would apply to overseeing cybersecurity risk. It is essentially the duty of oversight under the Caremark case. So the board's basic duty is to conduct informed oversight of the company's risk management related to cybersecurity. This means monitoring corporate controls and processes to prevent fraudulent or illegal actions. And the business judgment rule should apply to the board's management of cyber risk and protect the board's informed and good faith decisions. So the takeaway is directors do not need to become experts on cybersecurity, and they are permitted and indeed expected to rely on information and reports from management and others regarding cybersecurity. And I'll turn it now to Scott to kind of give some practical pointers with respect to board duties.
Yeah, and I guess what I would say, and the difficulty that we have seen is in getting our directors informed about cybersecurity risk is just the technical aspects of it. If anybody has been involved in any briefings on this, and I've had a few, I literally have had to read, and then have Kim explain to me, in very elementary form, exactly what we're looking at, what the risk is, and what the cybersecurity attack, the form that it took. So very, very complicated for directors to understand. Fortunately, there have been several, I think, very good sets of guidance and standards that have come out on director education, and I do think that has brought a bit of a plain English aspect to director education that has gotten directors at least to a level where they understand the basics. They've got a framework within which they can ask questions that about the programs, about the risks, and there are lists of what various organizations think are the basic levels of understanding that a director should have in order to perform oversight. Kim, I don't know if you have examples of trying to educate boards and best practices there that you might want to share with the group.
And I know we're going to cover that in a couple of slides, but there has been, I just think in the past 12 months, 2 years ago we were advising you need to become informed, you need to be engaged and ask questions, and now there's report after report that really does highlight different categories and areas, whether it's ISACA, Information Security Organizations, or the NACD, the National Association of Corporate Directors. I know that there's lots of groups, including our government, has been very involved, the DHS in particular, and other regulators in the SEC, in putting out information at a high level of what boards should be asking and how they should be engaged.
If you shrink all that down, though, on slide 7, I think we've got some practical questions that I'd like the presenters to discuss. How frequently does the board receive reports on cybersecurity and cyber risk? Is it one among many if you're a bank and you're receiving reports on credit risk, investment risk, et cetera, how does this rank given what's going on in the marketplace today as compared to other typical risks that a bank board of directors might see?
Well, I'll take that and we'll get your input on it. I think that in certain industries, high risk industries, financial services in particular, maybe healthcare is right there with them. That I think that there are regular reports. So that this is, if you look at a lot of surveys, boards, and particularly in certain industries, cybersecurity risk ranks as one of the top, 5 if not 3 items or areas of concern. And so, with the scrutiny that's placed on these issues and the fact that we're seeing them significant breaches every day, I think there are regular reports that go and to not to ruin the next bullet, but that go to the risk committee, risk responsible committee, which is often the audit committee. And then shorter forms of those reports that go to the board. But it's gotten to be not a once a year, here's what's going on. This is it is a continuous process of updating the board on not only the landscape but also the company protections and the development of those.
I would add that in particular where you have a big breach that's covered in the news, directors will want to know, how did that happen? Are we protected against that kind of a breach? So you'll want to make sure that you have reports to your board addressing breaches that are in the media and making sure you're protected against those kinds of breaches.
And particularly in your industry.
Yes.
If you were a healthcare company, or an insurer, you'd be looking at Anthem quite closely these days. Kim, did you have a comment?
Yeah, I was just going to say that some of the best practice guidance is that since cyber risks and threats can, and from what we read in the newspaper, do change quickly, that the oversight is sort of expected there'd be quarterly updates because at least once a quarter there can be a game-changing event or something important that's changed in the cyber risk landscape. So we see in the best practice guidance that although the board may only need to be informed annually of these, a full board or semi-annually, that the committees often are getting quarterly updates.
And that's consistent with, if you're talking public companies, that's consistent with really the meeting schedule of most public company boards and committees. Some committees meet more frequently, so the updates probably are more frequent than quarterly, but I think that's the appropriate flow.
From a practical perspective, who's doing this reporting? How is it done? If it happens on a quarterly basis, in what form is that provided to the board members? Are they seeing the same dashboard that the CISO, the Chief Information Security Officer, sees every day? Are they seeing line item budgets? I'm just interested in what information, how you package the information, how much of it there ought to be, and in what form it goes, in order to help address that differential between the technical nature of the information and the technical nature of the audience, or the lack of a technical nature of the audience. Kim, you work with boards a lot on this. What do you see about the form of the reporting?
I was just going to do the who's reporting first that we see, and we do see, in sort of broader, public companies, bigger organizations, not only, the first line of defense maybe being the operational group or the information security group, but sometimes an independent risk function as well that might be presenting to give sort of a second view to the board of the cybersecurity posture. And then in addition to that, sort of filter or including at various times outside consultants, again, to provide updates or different a different perspective on the cybersecurity posture of the organization. I do think on the how it should be presented is still, it's challenging in that you're right. I mean, there often is a sort of a risk scorecard or a dashboard, highly detailed, and then the challenge is who can present that, because it sort of feel like you need to convey all that, but then who can present it in English and interpret it, so you can, the board can get a feeling that they really are understanding in a non-filtered way, in a very, accurate way, the security posture of the organization. I think that you have the risk scorecards and the dashboards on the one hand, and then on the other hand, you have presentations as we have listed here on specific topics that are very important for the board to understand in terms of, next generation information security or what regulators expect. And one of those is threat intelligence. So you would expect maybe the board to hear about how the organization is getting information in from external parties to understand the cyber threat landscape and how it may affect their industry, and cybersecurity governance, how the organization is organized with respect to roles and responsibilities in cybersecurity. So in addition to the dashboards and risk scorecards, really understanding the way the company's organized around cybersecurity and other specific important topics.
Let me ask Jessica, the form of these can be, in substance, can be relevant in litigation that comes down the pipe. A lot of these, I guess, risk scorecards and so forth are identifying areas where you have potential deficiencies and so forth. What's the lesson for the board or management to deal, to make sure that those don't become a liability in litigation context?
Well, the minutes in the board materials will be the first thing that it will be given to the shareholder plaintiffs. They are quite literally your first line of defense. Also, the SEC and others will inquire into what the company and the board knew at the time of its disclosures, pre-breach in terms of risk factors and disclosures, and then post-breach, when the incident occurred. So it is critical to document what knowledge you have. And to your point, Scott, make sure that if you list any risks that you've identified, that you have sufficient detail around specific remedial actions. So if, for example, you list 10 areas of concern, and then you say you've got nice little check marks beside 8 of them that you've dealt with them and you feel comfortable, then you need to have specific action plans and deadlines for addressing the other 2. So don't just leave them out there. Those are low-hanging fruit for a shareholder to second-guess the board's actions with 20/20 hindsight.
So it would seem that the documentation of these issues can be both a lifeline, if you will, the first area of defense, or a noose if you do it improperly or without sufficient attention to detail, knowing that it's going to be such a critical item post-breach.
Yeah, I mean, you want to have strong documentation as the foundation for the discovery, because you're going to have communications at different levels that are not as structured that are going to be liabilities. And so you want to be able to point to the structure. This is what our board and our management have agreed as a structure, really to make the other chatter just chatter and not controlling any sort of liability perspective.
Right. Next slide. Scott, what is the SEC saying about this? We've got the guidance from 2011, I think it was, but some of the SEC commissioners have been quite active in the area. I'd appreciate your comments on it.
Yeah, so the SEC, mostly driven by the Congress and the executive branch, has stepped into the disclosure arena, but they've really gone quite far beyond what you would typically see them in mandating disclosure. A lot of times they'll say, make disclosure on whether you do this, that, or this or that, and it drives behavior, because if you don't do the prescribed thing, then you've got to embarrassingly say, yes, we don't have this committee, or we don't do whatever. Here, you're seeing particular commissioners, and really this has taken place mostly over 2014 with the roundtable. There have been a number of conferences and speeches, but particular commissioners coming out very aggressively and suggesting that beyond any disclosure you would have, that the board really has to be involved in oversight and has to be very active, and kind of dictating their views on the corporate duties of boards, which is quite unusual, at least in my experience. Commissioner Aguilar has been maybe the most active, and there are a couple of quotes that I just snipped here, and I'll summarize. But basically, he's saying boards, must take seriously their responsibility to ensure that management has effective risk management protocols, and the failure to do that, they do that at their own peril. So, those are pretty sharp words coming from the SEC. I think they're prodded because of the activity of the legislative branch and the commentary there, but something we haven't seen before.
Mm-hmm. The next slide 9, goes back to, and this was, Kim referred to some of this, goes back to some of the third-party standards that we're seeing about educating boards. Kim, do you want to talk about that, following on Scott's comments about the SEC saying thou shalt be educated, and now some third parties are stepping into the fray?
That's right. And if we think about what Jessica said earlier, that directors are not expected to be cybersecurity experts, when you read some of this guidance that's out there, it makes you wonder how they wouldn't be a cybersecurity expert after they asked and understood the responses to all the questions they're supposed to potentially ask their management. And I think it's really the level of specificity that we're seeing in this guidance that has changed, that we hadn't seen before. The FFIC guidance that's referenced here is applicable. The financial federal regulators say is applicable to all financial institutions, and really lays out a framework of categories for which they believe board of directors and management should be questioning and asking of their institutions, ranging from understanding cybersecurity inherent risk, so the risk posed to the institution, notwithstanding risk mitigating controls, Also understanding the cybersecurity preparedness, risk management oversight, threat intel that we talked about before, different aspects of cybersecurity controls, data classification, external dependency management or third-party vendors, if you want to think of it in that term, and then the cyber incident management and response processes as well. So it is very detailed, it's very specific, and it really does cover a wide range of topics that boards need to be thinking about in evaluating the cybersecurity posture of the organization. I realize that's just financial institutions, but we are seeing other industries, regulators in other industries also come out and expect that, not as specific of guidance, but saying as the SEC did, that they expect the board to be involved, deeply involved in these issues. Alongside with that, we're seeing third-party guidance. I think we mentioned earlier in the presentation the NACD has an oversight handbook. Again, very specific, different principles that if you read underneath the principles, really does expect the directors to understand the risk management framework that's been established at the organization, the level of exposure in detailed and technical ways. So on the one hand, I know we've been trying to identify how we can get boards educated on this topic without speaking technically, but when you read the guidance, you realize it really does get into the technical areas. And the last thing I'll mention, Jim, is I think it's hard as well because these are two pieces of guidance that we've identified, but there's others, and I think I came across one that said that the board of directors should be reading the NIST cybersecurity framework. And if you could imagine anyone outside of sort of the information security function trying to read it and understand it, it's a fairly complex document. So we're just in a very evolving state right now of trying to understand how boards can get better informed.
Well, with the inherent tension between the technical nature of the education and the non-technical nature of most boards, are we seeing a move to appointing board technology experts? Is there wisdom or guidance or thoughts on that from Jessica or Scott?
I'll just say I think boards do it different ways. There's no one-size-fits-all approach to that. It's not required to have somebody like that on the board, although some boards I think would feel maybe more secure with that type of a person on their board.
Yeah, and it's probably, as we've said before, I mean, the level of scrutiny varies based on industry, or level of risk, I guess, based on industry. So I think you're going to see in some of the the riskier, we'll call them industries, you'll have them looking for technically savvy directors. I do think that it poses a potential risk that you need to look out for, and that is that this person who's being brought on to be a director is a director, and their role is oversight, and their role should not be blurred with the actual implementation management of the cybersecurity risk programs and controls, and and somebody who is well known and experienced, I think there's a risk that there's some lines that can be blurred, and that and frankly management and the board are going to rely on them in ways that just need to be thoughtful.
It's going to create stress on that. So you don't want, if you've got a technology facile board member, you don't want them to become the de facto CIO or CISO.
Correct.
Yeah. Okay. And that will be inherently a difficult balance to strike.
Absolutely.
Next slide, please. So for those of you in New York, for CLE purposes, we're required to let you know of a code a couple times. There'll be another one later in the presentation. This code is C-Suite 15, C-S-U-I-T-E 15, and that'll be required for you to get CLE credit in New York, and we are required to intersperse that in our presentation. So we've done so. Well, with all of the documentation of the cyber risk floating around and flowing to the board, Jessica, can you talk to us on slide 11 about what will happen in a post-breach scenario with respect to some of the litigation and the demands for that documentation.
Sure. So next slide, please. There are likely two ways that you're going to hear from shareholders following a breach. One is going to be a demand for an investigation, and the second will be a demand for books and records. If you get a demand for an investigation, the board is going to hire counsel to conduct that investigation. And essentially the shareholder will send a letter that demands the board investigate the breach and take any action against any wrongdoers. With respect to the books and records demands, in the event of a breach, you're likely to get several of these. And again, they will come in the form of a letter from a shareholder. And by way of background, the long-favored approach under Delaware law is for a plaintiff to seek books and records and file, if needed, file a Section 220 action as an investigatory tool prior to commencing derivative litigation. So it's actually encouraged. And what happens when you get a books and records request? Well, they may be entitled to receive board materials and minutes. That's, as I said, usually the first thing that gets produced, materials related to cybersecurity, also the independence of the members of the board. We will negotiate a non-disclosure agreement before producing those documents, and they will be heavily redacted for privilege and responsiveness. So they're really only entitled to know what the board knew about cybersecurity, and that's it. Keep in mind the Walmart decision. For those of you who haven't read it, I encourage you to read it. It basically held that the Garner Doctrine applied in the context of a 220 books and records case, such that the company couldn't assert the attorney-client privilege vis-a-vis shareholders. It's our position that Walmart's very limited to its facts, but nonetheless, I think folks on the phone should be aware of the decision when you're creating your board materials and minutes. And so then what happens once you produce the documents? Well, they'll either go away, unlikely, but we have seen it happen. If they're not satisfied with the production and you're not willing to give them anything additional, they could file a 220 action seeking more documents. And then the third avenue is just to go ahead and file a derivative case. So what are we seeing in terms of derivative litigation? Well, the typical allegations in any kind of derivative case arising out of an incident like this is the breach of duty of loyalty and care, waste, and unjust enrichment. Some examples from the Target and the Windham complaints, and those are the two sort of ones that we have to look at right now, allegations of failure to implement and oversee adequate internal controls and governance with regard to data security, failure to establish positions with clear responsibility for data security, compliance with internal policies and risk management, allegations of failure to nominate or elect board members with a technical understanding, failure to require proper elevation of security alerts, failure to accurately notify customers. These kinds of allegations are what you're seeing in the derivative cases. They're very early in the life cycle, so we'll see whether courts find any merit. I'm going to talk in some detail about the Windham decision, but we do have an order in that case. The Target case, the litigation is currently stayed while the board conducts its investigation. So you can't prevent these lawsuits, and if you have a breach, you're likely to get a derivative case. But the best defense, again, is document, regular reporting and review of controls by the board, appropriate governance, and confirmation by the board that it's staying abreast of new and evolving threats in cybersecurity.
Yeah, your description of the allegation in those two pieces of litigation really corresponds quite closely to some of the themes that we've talked about earlier in the presentation. Governance, controls, risk management, were you properly informed, et cetera. So one is very much informing the other. What I haven't heard you talk about in today's comments, Jessica, is stock drop litigation. So what happens when the breach is announced and the stock goes down or doesn't go down?
Well, it's possible that a company could get a 10b-5 shareholder class action. To date, the markets have sort of done a shoulder shrug with respect to breaches, and you hear the term breach fatigue with respect to the market, so you haven't seen big stock price drops following breaches. And so without a big stock price drop, you're not going to get a shareholder class action. So we don't have any of those out there right now. It's more in the form of derivative litigation.
Okay.
So turning briefly to the Windham case, and as I said, I think it's worthwhile going through the opinion in some detail. We do, because it does give some guidance. Although I will caveat that with saying that the Windham decision is probably limited because of to its facts, because Windham had been through 3 prior breaches. So the board was very informed about cybersecurity. But so in that case, applying Delaware law, the court dismissed the derivative litigation filed against the Windham's board, holding that the board's demand refusal was protected by the business judgment rule. And just to back up, in Delaware, as a threshold requirement to bringing a derivative case, a shareholder must either, 1, plead in their complaint in detail that making a demand on the board would have been futile, or 2, they have to make demand, and then if the board conducts an investigation and subsequently refuses a demand, they have to show that the demand refusal was made in bad faith or based on an unreasonable investigation. So in Windham, the audit committee hired a law firm to investigate the shareholders' demand. The firm also had represented the company in the ongoing FTC action, the same firm. There was an investigation, and the board rejected the demand, and the shareholder filed a derivative lawsuit. The board rejected the demand for basically 5 reasons. 1, Windham had strong defenses to the FTC allegations, which the plaintiff alleged had caused his damages. 2, the suit would have impaired Windham's defenses in the FTC lawsuit. 3rd, the claims were not ripe. 4th, there was no damage to Windham's shareholders as a result of the FTC lawsuit or the underlying conduct. And 5, the shareholders' contemplated claims would face significant legal barriers. In other words, it was the board's view that the claims lacked merit. And the court found the last point particularly important. The court noted that the board can consider the merits of the shareholders' proposed suit when considering whether to file. Here, in the Windham case, the plaintiff's claim rested on the theory that the directors breached their Caremark duties, but the plaintiff actually conceded that the security measures existed when the breach occurred, and that the board addressed those concerns numerous times. The plaintiff asserted that the law firm was conflicted because of the FTC matter, and the court rejected that because the firm's obligations to act in Windham's best interests were identical in both matters. One other point that was important has been important to general counsels and other in-house lawyers that we've spoken to after the Windham decision, the court also rejected the plaintiff's assertions that the general counsel of Windham was conflicted because he faced personal liability because he was involved in setting up the company's data security in general. So the court rejected this theory because the plaintiff had not alleged particularized facts supporting quote-unquote intimate involvement by the GC in the cybersecurity effort. Second, the GC was indemnified. And third, the court held it's well established that fear of personal liability doesn't render a director conflicted. The plaintiff had also asserted that the investigation into the demand was unreasonable, and the court rejected this because, as I mentioned, the board and the audit committee had discussed the cyber attacks at 14 meetings, basically every quarter during the relevant period, and the board had a deep understanding of the subject matter. So great decision, but every fact pattern in this kind of a situation is going to be different. So we'll just wait to see how these cases continue to play out in the court.
Thanks, Jessica. So when you're preparing for a breach and going through the normal reporting requirements, talk to us, Scott, a little bit about the stress and value and risks associated with disclosure regarding cyber breach?
Pre-breach? Pre-breach. Well, I mean, I think...
And just talk to us generally about what disclosure can do in this circumstance.
Yeah, well, disclosure obviously continues to be under the microscope, right? It's been, I think if you look, the controlling guidance, if you will, is still from 2011, the SEC's guidance. As it's been modified by, roundtable conferences, the conferences and speeches, etc. I think at this point, pretty much everybody, every public company has, whether, regardless of industry, they have a risk factor that in some way addresses cybersecurity risk. As we started off this, you could not help but avoid, knowing that this is a topic that all directors and all management need to be aware of. So if you pulled out all of people's 10Ks, most all of them are going to have those. What I am advising, since we are kind of in the 10K annual meeting season, is that people do a refresh. I mean, they should continually be looking at their risk factors and at their other disclosures, but that they do a refresh. And that refresh, focuses on maybe 4 or 5 areas. First off, the SEC has said, you should have a cyber security risk factor that is independent of your other disasters can happen risk factors. So unbundle. So for companies, and there are still a few who say, tornadoes, blah, 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 cybersecurity, you need to think about whether that risk is significant enough for its own risk factor. Companies need to continue to consider, and this is a criticism of the staff, the risks that are particular to that company. I think there's a criticism that, the risk factors have become boilerplate. And while I don't necessarily agree with that, because there are consistent risks for cyber attacks that frankly affect most companies, particularly the consequences of that, I do think it's worth looking carefully at your company, your operations, and in particular, focusing on potential internal risks, and also thinking about your third-party relationships. So one area where there have been some breaches have been, lapses in third-party security that is tied into a particular company. So there may be some modification of risk factors that will cover those type of risks. The SEC continues to be focused on disclosing attacks, whether or not they're material, because they provide context, for people to understand. Now, as everybody knows, there are attacks that are incessantly going on. So, a statement that we are continually attacked, does that add much value? I don't know. But to the extent there have been breaches, even if not material and contained, I think you will want to consider doing that. And then the point that we started off with, Kim, is, we're looking at an evolving landscape. And it used to be smash and grab, more prolonged attacks. We've got, the Sony situation where a completely different risk profile, the destruction, removal for different purposes, not your typical take your credit card, sell them on the open market. The method of infiltration has changed. I think companies really need to think about, what those kinds of attacks, whether they are vulnerable to those kinds of attacks, different than the credit card attack, because I think almost every industry is subject to a Sony attack, right? I mean, take our stuff and use it in a way that's damaging to our company, and look at risk factors to make sure that those type scenarios have been addressed. One obvious point, just to tie this into our discussion on director involvement, is directors need to know what disclosure the company's making. And so while we typically have a practice of passing on a 10K to the directors to take a look at, I think I would highlight certain aspects of the disclosure in the 10K, particular cyber risk factors, so that the directors know what we're saying and that it comports with their understanding of what the risk profile in the company is. And I'll make one last comment on this kind of annual meeting period and disclosure, and that is, as we get into proxy season, the annual meeting proxies typically have, or they're required to have, a director risk oversight disclosure. Those have historically been somewhat generic, but I expect that in certain industries and for certain companies who have been victims of cybersecurity risk, that they will add additional disclosure that talks about their risk oversight of this particular, of the particular cybersecurity risk. Haven't seen a lot of those disclosures, but those are going to be coming in the in the next few months as people get into the proxy season.
Thanks, Scott. So those were very helpful comments about preparing the disclosure. After a breach occurs, Jessica, what stress does the disclosure come under, both from plaintiffs and the SEC and all of the other interested parties?
Well, it's going to be, again, what did you know, when did you know it, and who knew it, and with a 2020 hindsight lens. So the SEC is, whenever you come out with your disclosures, they're going to want to know what you knew when you made that disclosure. Is this a thorough disclosure? The same thing with shareholders and others that are looking at that. So it's, again, what did you know and when did you know it when you made the disclosure?
Which is so very difficult. As we've alluded to before, there's just complete uncertainty when you have a breach for what can be an extended period of time.
Is often months.
Yeah, and from a securities lawyer's perspective, I really hate to put out disclosure where we don't have definitive facts. And you're often, because of the, either the state agencies, the bloggers or otherwise, you're sometimes compelled to put out disclosure that is, we'll call it open-ended or incomplete, and that causes everybody heartburn.
You may never know the full extent of it.
That's right.
Yeah. So just a couple brief comments on insurance, Jessica. So does the typical D&O insurance policy address cybersecurity from a specific risk perspective, or do people need to go back and look at those policies? And then Jessica and Kim, how does that contrast to cybersecurity insurance, which is a question that we probably get once a day, if not more frequently, from all of our clients?
Well, with respect to D&O insurance, if you get a claim arising out of a breach against your directors and officers, you should be covered just like any other D&O claim under your policy, assuming some other exclusion or policy term would preclude coverage. So it's really no different than, if you had an earnings miss and you got a shareholder class action or whatever. In other words, there's no particular exclusion for a cyber event, so your D&O insurance should cover that. And now there's also this, it's not really a new creature, it's been around for a while, but the cyber insurance. And these policies and towers are designed to cover a variety of losses arising out of breaches, things like costs to notify customers, liability to third parties, etc. But those are two different animals in terms of types of insurance.
So, Scott, from a disclosure perspective, and Kim, from a kind of a regulator 2020 hindsight thing, are there people that are interested in the insurance question?
Yeah, absolutely. Yeah, go ahead, Kim.
Go ahead. I was going to say, yeah, absolutely, from a regulatory standpoint, and I think most of the best practice guidance we read about, as well as the regulator guidance, is, boards are expected to ask their companies and ask management whether they have cybersecurity insurance, and if they don't, why not? And regulators are certainly you can expect regulators might ask you the same. So companies are expected to at least identify whether they should have that insurance, and if they don't, why not?
Yeah, and I think in terms of disclosure, people are disclosing the fact that they have insurance as a potentially, as a planning thing that's potentially mitigating liability, but they're also disclosing that, that the liability insurance is not likely to cover all of the costs, and so they still have risk that could be material. That's the kind of form of that disclosure that's out.
Okay. Next slide, I think, is in New York. So if you're in New York and you'd like CLE credit, the code for this slide is BOD 2015, BOD 2015. I want to be sure, we've got about 15 minutes left in our assigned time. I want to be sure that we talk about what happens, what is the board thinking about when a breach occurs, and then I want to be sure and leave time to come back to a couple questions we've gotten from the audience. So you get a call, Krebs has called your PR department and said, I'm about to write a story on XYZ, and your incident response committee has convened. Now somebody's talked to the board. What's the board thinking about? What are they doing? What should they be doing? And how do you manage the board from a legal perspective post-breach? Kim, you may want to talk about that to begin with.
Sure. And hopefully they are, once they are contacted and once management is reporting to them, that they are familiar with that process. And we didn't cover this extensively before in the presentation, but one of the very important areas that they should be asking about is how is the company prepared to respond to an attack? What are the internal reporting mechanisms, and what's the response process? Who's involved in that process, and how does it work? In particular, if it's a significant breach. So hopefully they've heard from the company that this is the response process we have. We have a data breach response team that convenes. It convenes under these circumstances and brings in these parties as necessary, and does that very quickly, and then is prepared to report to the board. The one thing I'll say about reporting to the board, and it's probably consistent with the difficulty of the first tier reporting to executive management, first tier maybe being the data breach response team, is how critical it is to sort of avoid spinning the story, if you want to call it that. It's the people who are messaging it up to executive management and then messaging it to the board are always going to want to sort of filter it and say, oh, just something, we don't expect that it's going to be that big, we don't expect this, or we think it's only limited to this aspect, or limited here, or limited there. Sure, we're going to be able to we've hired our external consultants, and they're underway, and we're very confident we'll be able to resolve this. I mean, all that is sort of the natural inclination of how you want to report upwardly to the board and to management. And in these cases, can't stress enough how very much important it is to set expectations early on, especially if in the first couple of days of, we are at the initial stages of this investigation. We have one piece of information that we're running down, but the most important thing for you to understand now is we have the process in place. It's a process that we've reviewed. It's a process that we've tested. We've presented to you on how we've tested that, and we've got the structure in place, and the facts are just going to evolve as they evolve. I think that's sort of the most important part of the first initial communication to the board.
Yeah, that kind of reminds me of, telling my daughter not to be excited about summer break. There is going to be a high level of anxiety and energy in the room. Scott, from your vantage point of being a counselor to boards, what are they thinking about? What are some of the dynamics that you're dealing with?
Well, I mean, Kim summed it up pretty well. I think that what you have to do is put yourself in their shoes and understand that, as we said, they've been educated at some level about cybersecurity risk. They understand the incident, response plan. They need to trust all of those things. However, they are not experts in this area, and they do read the newspaper, and there's just great uncertainty as to what's going on. And so, I counsel them, that they need to be patient, and they need to let the investigation, develop, and not to jump to any conclusions about, the significance of the matter to the company or otherwise, and to wait really until we have some basis for them to start making some decisions. They need to, just as a practical matter, they need to be available, because we will have, these are around-the-clock events. We'll have, a number of board meetings over the course of particularly the first couple of weeks where, these people run their own businesses. They do a lot of stuff, but they've got to really make time for that, and they've got to be prepared to do that. But really, it's patience. It's, understand you've got the best team here to handle this matter. It's going to turn out, you're doing the right things. It will turn out in a way that, that it shouldn't be a big liability issue for you personally, getting people in the right mindset in that respect. One of the just practical guidance that we always give boards or give others in these kind of crisis situations, because people tend to have this panic attack and want to talk to other people, is to minimize written communication among directors outside of the privilege if you can, because there will be gaps where there's a board meeting on Monday and then not until Wednesday, and while there will be reports, what we don't want is directors emailing people with speculation and with with commentary, that uninformed commentary that's going to show up in one of Jessica's lawsuits.
Yeah, emailing either one another unnecessarily, or the worst scenario, emailing their cousin who's an information security consultant at one of the big four and just saying, what do you think? These are the three things that I heard at the meeting I just went to.
I mean, the number one is this is highly confidential. The spokesperson for the company is going to be designated as one or two people. You'll probably have a PR firm that's going to be taking incoming calls. Maybe you have a statement for them to return. Directors should definitely not go on record unless it has been agreed by the board. Directors shouldn't go on record, or really shouldn't even comment, privately about what's going on. That is in every extraordinary situation, really in any boardroom. You don't want that to happen, but particularly here because the stakes are so high.
I agree. None of that would be privileged in a litigation context if they're talking to their cousin or to other board members, unless somehow there was an attorney involved and there was a request for legal advice. So, there needs to be probably a point person, a point committee on the board that is getting the regular updates, and consider how often that gets reported to the full board. The chatter.
I want to turn now to some audience questions. We've received a couple questions that were sort of too specific and narrow, and we will get back with a couple of you after that. They're friends and colleagues of the firm, so we will get back with you individually on those. One question, Kim, that we've received is, and this kind of illustrates this theme of the difference in the language and the vernacular and what you need to do to be informed, is what is threat intelligence and how do I describe it to the board, and et cetera. So that's one of the things that the commentators are saying you should be talking to the board about, but here we've got a very sophisticated audience, and the question is, what is threat intelligence?
And it's an actual category that the banking regulators expect boards to be asking the organizations about. So threat intelligence simply is, information about the methods, tactics, types, and techniques of attacking a system or attacking a specific system. So it's information that a information security group can take from an external party. You might have heard of these informal or formal information sharing groups, and you can share that information so that an information security group can take that and be able to identify if they are under a similar attack. So it often is very technical data, and it might be, for instance, an IP address. I think most people are familiar with it. What an IP address is. It's a naming convention for a computer, and specific IP addresses can be identified as malicious. So if you're in a particular industry and there's been targeted attacks on your competitor from specific locations or specific IP addresses, it would be very helpful if you could have those IP addresses, because then you could potentially block the attacks on your system. So that's what's essentially occurring in this sort of newly forming way to help companies prevent, detect, or respond to attacks, is sharing of these indicators of how other organizations, technical indicators of how other organizations are being attacked.
Thanks, Kim. Another question that we've received, a couple of questions in this area, is what do board directors ask about their personal liability, and how do you respond to that in the cyber breach context? I think, as Jessica mentioned, the standard rules of the road apply with respect to board risk, but what kind of questions do they ask once the hackers have gotten in and the wasp nest has been hit?
I'll just kick it off. I think they're going to want to know about their indemnification. They're going to want to know about the insurance that's in place, and they're going to want to know that covers the claims that may come in against them personally. And so it'll be important for either risk officer or the GC or someone to report to the board about the types of exposure and the fact that they're covered through indemnification and D&O insurance.
Yeah, this is, although it is certainly an area of focus right now, the duties that apply are the same duties that apply in normal, ordinary course board activities, and those typically, without some, with limited exceptions, related party, bad faith, related party otherwise, their personal liability does not attach to directors. So, we would typically, in our initial, here are the fiduciary duties that apply, we would, make the statement that, personal liability should not be an issue under these circumstances.
So kind of the reverse of that, what questions are board members asking regarding their personal liability? We've also received what I think is a good question. What questions should management anticipate that the board will ask of them regarding cybersecurity risk and cybersecurity preparedness?
Well, Kim, this is probably better for you, but that's the core of the board's education and understanding, and as we said, being informed, which is one of the foundations of the duty of care. So, Kim, you probably have been in those situations more where the board is asking those questions. What can you categorize them in a kind of summary fashion?
I guess I would say just, if you think about someone who isn't involved in this area, the first thing they might want to know is, well, is our company attacked often, or what are the types of attacks that our organization normally faces? How many? What's the volume? What are the types of attacks? Have we ever been attacked before? How have we responded? What's our exposure is one of the first questions that boards usually ask. What's our exposure, and what types of controls, or how are we protected against those attacks? Give us an idea of what our risk exposure really is. And then secondly, what are we trying to protect? I mean, what are we afraid can be if we are attacked and they're successful that they can take? What are our crown jewels, and how are we how do we specifically protect those crown jewels from being taken? I think those are sort of the initial first questions that they ask, and then thirdly, what's our governance structure, or who's responsible for information security or cybersecurity, and are they qualified? And what's the structure, and who do they report to, and do they have enough resources and adequate resources to do the job that they need to do?
Okay.
Both internal and external, right? And what are their qualifications? And then I hear boards saying, if this all goes wrong, as we've just gone down the parade of horribles, what are the parade of horribles and the legal risk among others?
Right. So we've got a couple minutes here in conclusion, but I've also received two good questions about when do you bring an incident to the board? For the hundreds, if not thousands of times a day that a network gets knocked on by a potential threat actor, what distinguishes between one of those normal pings that hits the firewall every day and something that should be elevated to the board? And Jessica and Scott, you guys, and Kim may all have interesting thoughts. 2 minutes on that total.
I'll start and just say, it's going to be very fact specific, and you're going to the board is going to need to rely on management to make those kinds of calls. Certainly to the extent that you have a breach and customer data or personal data, it has left the company, those kinds of breaches. But the day-to-day, you really have to rely on your information security folks to kind of make those calls.
Scott or
Kim.
I
would just add that, and hopefully you have outlined in your response plans what sort of the trigger is for the response team. But if there's an incident, and you kind of know it when you see it, because 95% of the time the information security group will have noise, the attacks will be more along the lines of noise. But I would say if it potentially significantly affects or impairs the organization's ability to function, or any significant operational lines, or a significant legal exposure, you don't want to run to them if there's a lost laptop with only a couple records. But if it's a lost laptop with 3 million records, you might need to. So some level of a threshold of significance in the incident as well.
Okay. That brings us to the bottom of our assigned time. Thanks, everyone, for joining us today. Thanks very much, Kim, Jessica, and Scott, for your thoughtful and insightful comments. You will receive a copy of the slides via email. You will receive a certificate of attendance, and there have been a couple offline questions that have been asked that we'll come back to individuals on outside the context. So thanks very much. Follow us on Twitter at Alston Privacy, or visit our blog at alstonprivacy.com for follow-up information. Thank you.
Thanks, Jim.
That does conclude today's conference. We thank you for your participation.